Okay, good morning.
Morning.
Morning, Your Honor. How are you this morning?
Good morning, sir.
Morning, Judge. How are you doing?
Morning. Good to see you all. Court will begin with the March 9th, 2022 docket. And we're live streamed here, folks. And I believe we're here on CL 20-0588D, Miguel Arechar versus Alexis Aleman et al. And it's a motion to transfer?
Yes, Your Honor. And we filed that motion to transfer and consolidate as our motion states. And from my understanding of it, I mean, I was new to the case as well, but there's I believe 3 ongoing lawsuits, one filed in County Court 4 by Mr. Rubio and one in County Court 2 filed by another attorney, and then that same attorney also filed one in the district court. So we're asking that that the court in this case, for this case that we have here before the court, grant us the motion to transfer this case and consolidate it with the one that's in the district court. Is that correct, Mr. Rubio?
That's my understanding, Your Honor. I think what we need to probably do, because I think we also have a hearing next week in court number 2. I think we're trying to go into the district court. So I think we need to file a motion to consolidate in the district court. Obviously, you can transfer it to the district court, but I think the district court has to okay that first.
Right.
Mm-hmm.
So I think we need to file a motion to consolidate in the district court and have that judge rule on it. And once we do that, I mean, that's the proper court. It's the district court. So that's the court that'll take it over. Martin, or I guess it's Mario Davila's office, is the one that filed in both counties. And my understanding is we now also have Julian Guzman in. I think everybody's in agreement, other than no one's been able to contact Mr. Julian. But I don't see him being opposed to putting all the cases together. I mean, that's the proper thing to do.
So then we wait to see what the district court's going to do?
I mean, they'll sign off on it, but I think that's our next step, because you can transfer it, but if for some reason the district court says no, then we're in limbo. Yeah, it'll come back, or we're kind of stuck, because I think we have this same motion scheduled in court 2 for some reason next week.
Okay. So then no action today. We'll leave it alone, folks. Let's see what they do at their district court.
And if the court, so we don't have to bother the court again, if I guess on the record, if the district court agrees to accept it, will this court honor that agreement? And that way we don't have to file, we just file the order with this court and then it gets transferred?
Just let us know. Yeah.
Okay.
That'll work.
Very well, Judge. So then if like Mr. Rubio said, if the district court, I believe it's the 464th, is in agreement with the transfer and they'll accept this case, then we just can file an agreed order with this court and have everybody sign off, and that way we don't.
That way we know.
That'll work.
Okay, Judge.
That'll work. That'll do it. Thank you all so much. Your excuse.
Thank you so much.
Have a good day.
You as well. Take care, Judge. Bye-bye.
All right. I see you more in commercials than I see you in court there, Mr. Rubio.
We need to change that, Your Honor. So hopefully we'll be in there soon. Really, let's get us live, and that way I can send my daughter. I have an associate and I haven't been able to punish her yet and send her to court for the early hearing. So I told her wait till real life begins again.
Okay. Is that Vanessa?
That's Vanessa, yes.
No,
so
Vanessa. Okay.
We'll get to find Peter. But
Okay.
You take care, Judge. Good seeing you.
All right. Take care. Bye-bye.
Bye.
Mr. Cantu and Mr. Hicks, number 6, number 7, and number 8.
6, 7, and 8. That'll be CL 21-3361D. Philegonia Site Contractors LLC versus Grislam Construction et al. And we have here Mr. Hicks and Mr. Cantu.
Rolando Cantu here on behalf of Philegonia Site Contractors, Your Honor.
Yes, sir. Morning.
Morning, sir.
Good morning. James Hicks here for Hellas Construction, Inc.
Yes, sir, Mr. Hicks. Good morning. We got special exceptions, motion to dismiss, and the plea to the jurisdiction. And whose motions are those?
They're mine, Your Honor, for
Okay.
Hellas Construction, Inc.
Okay.
And I'll probably start with the motion to dismiss and the special exceptions, a bit of an alternative relief if you're inclined not to grant our motion to dismiss.
All right.
May I begin, Your Honor?
Yes, sir, you may begin.
Sure. So Philogonia's lawsuit pertains to the City of McAllen's youth baseball complex, which is on 29th Street in McAllen. The City of McAllen hired my client, Hellas Construction, Inc., as the prime contractor on that project. Hellas had a subcontract with Greslem Construction. Greslem Construction, in turn, hired Philogonia site contractors as a subcontractor. Philogonia alleges in the lawsuit Greslem did not pay for Philogonia's work on the project in 2017. So Philogonia filed suit on October 1st, 2021 against Greslem Construction. Paragraph 8 of the petition, and this motion to dismiss is just based on the pleading, is not an evidentiary hearing. Paragraph 8 of the petition sets forth the cause of action where Philogonia is alleging the defendant, and I presume that means Greslem Construction, breached its contract by failing to pay the amounts due to plaintiff Philogonia in the amount of $27,800. So Philogonia also named Hellas Construction as a defendant, and that's why I'm here making my motion today. But Philogonia cannot have a breach of contract action against Hellas Construction because it lacks contractual privity with Hellas Construction and doesn't plead anything to the contrary. The Texas state law, chapter 2253 of the Texas government code, does provide a procedure whereby a subcontractor like Philogonia could have made a bond claim on Hellas's payment bond for the project, but Philogonia did not file a bond claim. So we've moving to dismiss under Rule 91A because there's no basis in law or no right to relief against Hellas Construction, and no jurisdiction because there's no standing to sue Hellas for a breach of contract, and no jurisdiction for a bond claim under Chapter 2253, and no bond claim is alleged as part of the lawsuit. So, and I would also note that under Rule 91A-4, the time to file a response to a motion to dismiss is 7 days prior to the date of the hearing, and we haven't received any response.
All right, thank you, sir. Mr. Cantu?
Your Honor, that's correct. Well, there's been no response. I've had a couple of setbacks and I just missed it. I mean, I have no excuse. I've had a couple of deaths in my extended family. So I had a cousin in Falfurrias and I had to attend. And recently, Dr. Garza, who's my brother-in-law, just passed away. So I missed it. I mean, that's correct. So I would ask for leave to file a response, number one. But number two, Your Honor, what counsel is not mentioning is that Hellas asked Philogonia to send them the bills because the Greslem was not paying. Okay. And there has been some payments made by Hellas to both the Philogonia and to Greslem. So, Your Honor, to sit here and say that there's no contract, well, they put themselves in the position. Okay. Additionally, Your Honor, in the contract, the cause of action is, hey, we're owed $27,500. And so they're trying to move it over to Austin because of the contract. Well, the contract that they have signed has some interesting conflicts within the contract as far as venue and as far as jurisdiction. So, Your Honor, we feel that this case should remain, and he has not put on any evidence disputing us, and there's no evidence as far as the cause of action, and there's no evidence that he put up as a fact. So Rule 91A specifically states, that there's got to be law and there's got to be facts, and so we provided both.
Okay.
Your Honor, I'll just clarify one thing.
Okay.
Yeah, and just to mention, as part of my moving to dismiss, I think I am inherently waiving my motion to transfer venue by appearing before the court and asking for that relief. The point I had made with the motion to transfer was that if there had been a suit by Greslem Construction under Hellas's subcontract with Greslem, which Philagonia really can't do. Can't file suit under a subcontract between Philagonia cannot file suit under the subcontract between Greslem and Hellas. And so I was just making the point that if Greslem sues us, which they have actually in district court, and we have a counterclaim against Greslem, and that dispute, I have a motion to transfer venue pending, and I didn't want to waive that. And so I think I was being a little bit too careful there. With respect to Philagonia's claim against Hellas Construction, my only point here today is that there is no basis for that cause of action because there's no contractual privity and no jurisdiction under a payment bond kind of theory of suing under Hellas's payment bond. So those are my points, and I concede the point about the venue.
Okay, you were saying specifically paragraph number 8.
Yes, you have the petition in front of you, Your Honor, or should I share my screen?
No, I'm gonna look at it later on. I'll
Okay.
look at it later on. So, but I think you mentioned number 8, right? I think you said.
Yes, that sets forth Philagonia's cause of action in the lawsuit.
Okay.
Yeah.
Okay, that was okay. You mentioned number 8. Okay. All right. Did you say there's a district court case already?
There's a district court case where between Greslem and Hellas,
Oh.
and Hellas has, I think to Mr. Cantu's point, what he's saying is at some point Greslem wasn't paying its bills and Hellas took over the project. However, there's nothing in the pleading, and I haven't seen any evidence, but more importantly for today's hearing, there's nothing in the pleading that says, well, we did this work for Hellas. This work is in 2017, which seems to mean that was work that was done for Greslem before Hellas took over Greslem's role. So, but to the extent that that's the case, that would need to be pled, and it just hasn't been. So I think, to this point, there's no theory basically that would set out a contractual privity between Philagonia and Hellas because this work was done for Greslem in 2017.
Okay.
But there is that dispute in district court between Greslem and Hellas, and we have a counterclaim there for our excess completion costs after we did take over the project from Greslem.
Is it in
later.
Is it in this county?
Yes.
District
Yes.
court, this county? Okay. All right. All right. And Mr. Cantu,
Your Honor, may I
Yes, sir.
respond
sure.
briefly? Basically, Hellas Construction has accepted the labor and materials furnished by Philagonia, okay, which is pled in the response to their motion to transfer venue and plead to the jurisdiction. Additionally, Your Honor, the baseball field is mentioned on paragraph 3, and on paragraph 4, venue and jurisdiction is proper here, Your Honor. So they've accepted, okay, all the materials in this case. So, I mean, so what's happening between them and Hellas in this county, we may have to intervene too because of the contractual issue. We are interested parties in that. We were not aware of that Hellas suit because we can't find Greslem, or one of the people supposedly has died. Okay, so we would probably want to set up a default judgment here in this court on one of the defendants, which would be Greslem. So they have not answered. So we have not been able to serve them. So
But
that's still pretty confused. It's very confusing right now.
but
Well,
that's question.
I can add a little clarity on that. I mean,
Okay.
I think Mr. Cantu's on point, which is his claim against Greslem Construction for non-payment. We have, it had Philagonia filed a bond claim timely, Hellas may have resolved that bond claim, and that would be then part of our counterclaim against Greslem, with Hellas having stepped in and made that payment. Philagonia not having filed a bond claim, they're in an unfortunate position of not having a relief against Hellas here. But I certainly don't dispute that they would be entitled to a default judgment if they have proper service against Greslem.
Your Honor, additionally, Hillis has placed themselves in this contract by paying. We've been paid for part of the work, not,
Okay.
and these are materials, Your Honor, that my client is out of.
Okay, Mr. Cantu, you want to leave of court to file which response on the motion to dismiss?
Yes, for the 91A.
The 91A motion to dismiss. Okay. All right. Yeah, I think Dr. Garza's funeral is still going. I mean, it's still already.
Dr.
Service already done.
Dr. Roman Garza passed away
I
Friday.
know, but the service is still passing, are still pending, or what?
Yes, no, Your Honor, it was yesterday.
Yesterday, there you go. I knew it was
Yes, sir.
It
was yesterday, and yes.
Yeah, and then you had another relative,
Yes.
also. I remember.
In Falfurrias, yes, sir.
Yeah, it's hit you pretty hard there.
Yes, sir.
Well,
It's been, and at my age, you know, we do have senior moments. And Mr. Hicks has been very, very kind as to remind me that and giving me the so he's a young man. So
when you start having gray hair, you start having senior moments.
So yes, Mr. Hicks and I'm sure we'll work well together, Your Honor.
All right, I tell you what. Yeah, we'll go ahead and grant the court will grant you the leave of court to respond to the motion to dismiss. And then what I want to do is I'll just take all three motions under advisement and hopefully have a ruling as quick as possible.
Very well, Your Honor. Will the court be kind enough to grant me 14 days to file the response?
Well, yeah, I'll give it 14 days.
Very well.
Okay, and they're under advisement. And so thank you all so much for appearing. And let me look at this petitions again. Okay.
Your Honor, thank you very much. And Mr. Hicks, thank you. And you guys stay safe.
Yes, sir. And my condolences, Mr. Cantu.
Thanks, sir.
All right. Thank you. Bye-bye.
Thank you.
Have a good day. Under advisement, this one?
Until March 23rd.
Okay.
And we have Mr. Garcia.
Mm-hmm.
Joe Garcia. I'm assuming he's here for the protective one.
Okay. Where's the,
He's connecting.
Okay.
It's number 10.
Number 10. This one, number 10?
Mhm.
Okay. All right, Mr. Garcia is connecting. I think he's already connected. Good morning, Mr. Garcia.
Yes, sir.
Yes, sir. Good morning. We're here on the March 9th, 2022 docket, and I believe you're here on P0151-21-4.
Yes, sir. We were asking
And
for a reset, Judge, on that.
Submit the
okay,
extension.
submit the extension, sir.
Okay, thank you, Judge. Appreciate it.
And once again, Hermenegildo Martinez versus Claudia Martinez, P0151-21-4. All right, thank you, sir. Your excuse. Have a good day.
Number 5.
Hmm?
Mr. Robert.
McLaughlin, right?
Mhm.
Mr. McLaughlin.
I'm sorry.
All right, there you are, Mr. McLaughlin. Good morning, sir.
Good morning.
I believe you're here on CL 2014-50D, Bank of America versus Reynaldo Salinas.
Yes, I'm here on that one. And I'm also here on Portfolio versus Anadina Perez.
Number 1.
Number 1, there was no.
Okay,
service.
on number 1, let's go to that one. CL 183235D, Portfolio Recovery Associates LLC versus Anadina Perez. It is my understanding that there was no service on the defendant.
Okay.
Yours was returned.
It was returned unserved. Unserved? Is that what it is? Okay. Would you check on that, Mr. McLaughlin?
I will check on that.
And once you find out something, just let us know. We'll reset it again.
Okay.
Okay. Thank you, sir, on that one.
No
Let's-
action.
No action on this one. I'll put no action. And then let's go back to the CL 20 1450D, Bank of America versus Reynaldo Salinas. Court will take judicial notice of the entire file, and court will note that Mr. Salinas is not in the waiting room. You may proceed, sir. You're muted, Mr.
Okay. Yes, sir. So they opened the case in 2005 with a last payment in April of 2019. The account was closed and charged off with a balance of $9,532.25. We're seeking that amount in damages plus costs to the court, and we're asked the court to take notice of the business records, non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested hearing in open court or in its petition. Court will await a default judgment for signature.
Thank you, sir.
Anything else, Mr. McLaughlin?
No, sir. Thank you.
Yes, sir. Thank you. Have a great day. Your excuse.
You too.
Number 2.
Number 2. All right, number 2 here. 4048. Who's on this one then?
I don't know. He's under Gutierrez, Ben Gutierrez.
Okay.
He's connecting.
All right.
This is where the defendant is in federal custody,
Okay.
as per the mother.
But I don't see the attorney on this one, right?
I don't know if Mr. Gutierrez is in the attorney.
All right. You want to go to another one where he's connected?
To proceed.
Okay.
No change.
All right. All right, good morning. You need to unmute.
Okay.
All right, there we go. Good morning. Can you hear me now? All right, we're here on F5482-21-4. I believe it's an application for a name change.
Yes,
All right, and it's regarding Dianel Rosano
Daniel.
Daniel, yes. Daniel is also last name.
Oh, okay. I thought it was a typo. Okay, in regard Dianel Lozano Daniel. And I think the name change is gonna be to Ofelia.
Yes, Lozano.
It'll be Ofelia Lozano Daniel.
Just Lozano.
Or you want to kick out the okay.
Yes.
You want to take out the Dianel and the Daniel, right?
Yes.
Well, what is the reason for that? For mass confusion?
Yes. It's always a confusion in her name. So
All right, court will take judicial notice of the file and the entire file here. And you have I've heard enough already. So I think I'm confused enough. So we'll go ahead and grant it. So it'll be Ofelia Lozano, right?
yes.
All right.
That's okay.
All right. And you're Ofelia, right, ma'am? In the blue?
Yes.
That's your new, that's going to be your new name from now on. Congratulations. You're not doing it to avoid creditors or avoid the police or anything like that?
No.
Okay. Just for the sake of mass confusion, right?
Yes.
All right, it's granted. Anything else?
That's it.
That'll do it. Thank you all very much. Your excuse.
Oh, okay, I have a question.
Uh-huh.
We're gonna travel next week. So it's gonna be a problem with the passport or?
I think
If she has a passport under this name, she
Okay.
needs to stay with it like that.
stay like that until later on, because to change anything with a passport is going to take weeks or months.
Oh, okay.
So just leave it
perfect.
alone. Yeah, leave it
Okay.
alone.
I can
Okay.
use the one we have, right?
Yes.
Yeah, okay.
Keep
perfect.
using that. Keep using that. Yeah.
Or
Okay.
what you can do is not sign the order until next week. That way there's no,
When do you come back from your trip?
It's gonna be 1 week, less,
Okay.
yeah. Mhm.
All right.
Next,
Is it court will sign the order later on?
I guess we can sign.
We'll sign it like in 10 days or something.
On the 21st.
oh, okay,
The 21st,
March.
March 21st.
It'll be signed March 21st. So don't
That
worry
way-
about it. Enjoy your trip out there.
That way
Okay.
there's no problems.
thank
And there'll be no
you.
problems.
Thank you.
All right. Y'all excuse. Thank you very
But
much. Oh,
Matt,
Thank
but she knows
you.
that she needs to submit everything to Austin, right, to change everything, and
you understand that, ma'am, that once you get a court order that is certified, you're gonna go through a lot of paperwork with Austin and where else?
she needs to go to the county clerk,
The
there's
county
a
clerk.
form, and then she needs to submit a certified copy of the order that you're gonna sign, submit
Right.
it to Austin.
Yeah, it'll take a little paperwork.
Okay.
We can do it after the 21st. Okay.
Okay, perfect. Thank you
All right.
so much.
Thank you all. Bye-bye. Have a good day.
Bye. You too. Bye.
Mr. Gutierrez.
Oh, Mr. Gutierrez.
Good morning, Your Honor.
Let's see, Mr. Gutierrez. Let me see here. Let's see.
Number 2.
CL 194048D, One Main Financial Group LLC versus Raquel Herrera. It's a motion for summary judgment, right?
I have it listed as default judgment, Your Honor, but it's
No,
summary
it's an
then.
MSJ.
It's an MSJ.
It's an MSJ.
It's an MSJ that I have for. Obviously, it should probably been an appearance, but
The defendant is in federal custody.
there's a note here that I have here in my file that defendant is in federal custody, and but did she ever file a response to the MSJ?
Not that I saw, Your Honor, but
Okay.
and again, I listed it as a default, so
Okay.
I don't think I was looking for a response.
All right. Let me see if my staff can tell me, Rick,
Yes, sir, Judge.
on CL 194048D, One Main Financial Group versus Raquel Herrera, who is in custody. Do you know if she filed a response to the MSJ?
Judge, there is no response on file.
Okay.
I know that there was an order setting hearing for default, but the order came in titled as motion for summary judgment.
For the MSJ? We're the one? Mr. Gutierrez,
Yes, Your
do
Honor.
you know where she got served?
She was personally served in Edinburgh at 3919 Albanian Street.
3919
Albanian?
Albania Street in Edinburgh.
Correct.
She got served personally?
Yes, Your Honor, on August 8th of 2020.
Okay. All right. Rick, do you know if there was did you file an answer, a response?
No, Judge, but on January 28th, I took a phone call from defendant's mother informing the court that the defendant child was in custody, federal custody in Mississippi, and she was unsure as to when she would be released from that facility.
Okay. Okay. All right. So Mr. Gutierrez was gonna seek default judgment, but then we have an MSJ here. And then there's no.
The mother received notice, but there was no response on file on behalf of the daughter.
All right. Should we just set it again for default judgment? Maybe we should just reset it again for default judgment, Mr. Gutierrez.
Understood, Your Honor.
We'll send notice to everybody, but even if she's incarcerated, we'll still proceed.
Understood, Your Honor. All right.
Give me a quick order setting hearing date. I mean, give me an order setting date, and I'll give you a quick setting.
Understood, Your Honor. I shall do that.
And because we want, I just want to make sure we do it correctly, so there'll be nothing down the line.
And is that to be e-filed or emailed to the coordinator?
E-file?
E-filed. Understood.
Yes, sir.
All right.
So let's do that. Let's just for sakes of doing it correctly and so forth. Let's do it again.
Okay. Understood.
All right. So no action today on this one. Anything else, Mr. Gutierrez?
That's all I have before the court today, Your Honor.
All right. You have a great day. Stay safe.
You as
Okay,
well,
sir.
Your Honor.